Good morning, everybody. Welcome to the Courtroom Files Live. We're going to start today in the 23rd District Court in Taylor, Michigan. This is Judge Shackelford.
.326 to 329. You have permission to go to Kentucky to visit your children. Mr. Nicholson.
Yes.
If you don't hear from the probation department within a week, you need to call up here and make sure nothing gets lost in the mail.
Okay.
You have to, so that interview will be set. And we'll see you back at your sentencing date.
Okay.
All right, you're all set.
Thank you.
All right, this is 250169 SM, the state of Michigan versus Derek Jones.
Morning, Your Honor. James Kazicki on behalf of Mr. Jones. The Honor, we're moving for dismissal. This is set for a settlement conference. Victim failed to appear.
All right, complaining witness failed to appear. The case will be dismissed without prejudice. Mr. Jones, that means that the prosecutor could still reissue these charges within the statutory allowable period. But for now, the case is dismissed without prejudice.
Yes, ma'am.
All right, you're all set, sir.
Thank you so much.
She's ready.
He popped on. She had been talking to him, so I don't know if she's still on Zoom or.
Mr. Dudley, give us just a moment. I have the file. I'm waiting for your attorney.
Yes, ma'am.
While Judge Shackelford's gone quiet, let's go over to Judge Washington in 14B, I believe it is, in Washington County.
Definitely more than just an outburst. I definitely should not have went that far.
Okay. It's the sentence of this court, ma'am, that you serve 365 days in a Washington County jail. Credit for 1 day served. The balance of that is going to be suspended for now. If you do what you're ordered to do, then you won't have to serve any additional jail time. If you don't, then you're going to do some jail time. Do you understand that?
Yes, ma'am.
You're on probation for a total of 12 months. Fines and court costs in this particular case for a total of $425. Restitution is to be determined. You're to meet with probation when and where directed, including any and all home visits. You're to make earnest efforts to maintain legitimate employment. No assaultive or threatening behavior towards anyone. You're to complete the Class A training anger management program within 90 days. There's no contact with Elijah Biddles. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or any police officer. No use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, no being in the presence of anyone using any of those substances. The same is true for firearm components, ammunition, and other dangerous weapons, and no being in the presence of anyone carrying or using them. You are going to drug test 3 times per month. Until approved for a marijuana card or until you are showing that you are clean of it. You need to do one or the other. You are not to continue to use marijuana. Do you understand that, ma'am?
Yes, ma'am.
I will see you back here. I'm gonna make this 60 days on June 2nd, 2025 at 10 o'clock a.m.
For national debt relief, my
HIDA is granted. Ma'am, if you don't do what you ordered to do, you will not get HIDA. You understand HIDA allows for this to not be on your record if you do what you're supposed to do?
Yes, ma'am.
So stop using the marijuana or get a card that gets approved by me, okay?
Yes, ma'am.
All right. You need to contact the probation department. Do you have their telephone numbers?
Yes, ma'am.
All right, call them tomorrow after 9 o'clock a.m. so you can sign your contract. Good luck to you, ma'am.
Thank you, Yanni.
Welcome.
Thank you, Judge.
You're welcome.
Let's head over to Judge Middleton's court, St. Joseph County, Michigan. He is doing a motion for summary disposition.
Mr. Duquette, we're ready to go.
All right, good morning.
Good morning.
good morning.
This is a case with a motion for summary disposition. Title of the case is Discover Bank versus Samuel Fitro. File number is 241590GC. The claim is for $11,675.49 plus cost, interest, and attorney fees. The lawsuit was filed. It was served on Mr. Fitro. He filed a defense, the actual answer with a general denial, and that resulted in the plaintiff filing this motion and accompanying exhibits on a motion for summary disposition. Attorney Thomas Duquette is here from the firm of Weltman and Weinberg representing Discover Bank. Mr. Fitro, I know that you're crunched for time. You're at work. You had asked to adjourn this, and I didn't really wish to, so I wanted to try to address it this morning. A motion for summary disposition, as they told you in the brief, contends that there is no material issue of fact, and you have not stated any defense. And they're asking that a judgment enter in their behalf for the amount pled for. You filed an answer, and you did a pretty good job of it, but it was an answer just of a general denial that you got somewhere, which gets you past the default, but it doesn't necessarily get you past a motion for summary disposition. They did attach the exhibits with a charging history on this credit card. And they contend that you haven't stated the defense and there is no material issue of fact. It simply is what it is. Mr. Duquette, do you wish to speak to that further?
Yeah, Your Honor, I think you were kind of spelling out where the court was going with the court rule. Once the plaintiff makes a case, it's the defendant's burden to provide evidence that contradicts it or creates a genuine issue of fact. We don't think that's happened here. We attached all the account statements that were sent to the defendant at his current address. He never objected to those statements as he received them. He has not provided any evidence here that contradicts plaintiff's damages amount. And based on those things, we think summary disposition is appropriate under C-10.
Mr. Fitro, is there anything you'd like to tell me?
Yeah, unfortunately, I was working with National Debt Relief and this was supposed to be all avoided. I was trying to do the legal proper thing to do to catch up financially. Just didn't really work out. However, I did get them to close on this situation a few days ago. So we actually have signed an agreement with Weltman Weinberg Reese already, which I did get out of work, by the way, this morning by chance. So I came home this morning. I guess that was it. I didn't know if there was going to be a case this morning because we signed a paper the other day.
All right, well, let me ask about that. Do you have any knowledge of that, Mr. Duquette?
I had not seen anything about that. I'm looking through the file right now.
Yeah, and it actually worked out terrible for me. I think I'm paying for court costs and everything, which it did not help me at all trying to do this. So I have regrets on trying to handle this in a different manner. We should have just kept paying as we were before National Debt Relief. My wife and I had I'm going to use the word religiously paid on our bills. We were not falling behind. We decided to follow the advice of professional lawyers, and it did not work out. So,
Well, I'm sorry about that. Some of these debt consolidation companies are better than others.
yeah. The other
Sometimes I see
cards,
people.
yeah. I'm sorry.
All right.
We had
So
some other
it's-
cards work out great. So,
All right, it's your contention that you resolved this case with Discover
Sure.
Bank?
yeah.
That appears to be accurate. I missed this.
Okay.
In reviewing the file, it does look like a consent judgment was mailed out to him last week.
All right, well, how about if we continue this for 2 weeks and wait for the consent judgment to enter?
I think that's a good idea.
I don't know what that means, but thank you.
All right. We're going to adjourn this for 2 weeks to wait for this consent judgment to come back in the mail. If it comes in, the case will be resolved and nobody needs to appear. Maybe I'll give it a little longer than 2 weeks. Today is March 24th.
Yes.
How about if we adjourn it to April 28th?
Okay.
That should be plenty of time, and that works for plaintiff.
At 10 a.m. I expect the consent judgment will be entered in the meantime. All right, Mr. Fitro, your information was accurate. Thank you for being here to help us understand it. I'm glad, I guess you didn't have to miss work for this.
Yeah,
I expect that the matter will be resolved with this consent judgment and dismissed. Or this case will not be necessary for hearing on summary disposition. If that does happen, nobody needs to be here on April 28th at 10. If it does not happen, we'll make further record at that time. But I'll give it a whole month to make sure we get the paperwork cleared and filed. All right, Mr. Fitro, you can get back about your day, and Mr. Duquette, so can you.
All right.
Thank you all.
Yeah,
All right,
thank you for your time.
Well, that's why I'm here. Good luck to you, sir.
Thank you. All
Have a good
right,
day.
take care.
Bye.
I don't know what that means, but thank you has to be one of the most trusting statements I've ever heard out of somebody in a court. Good morning again. Welcome to the Courtroom Files Live. I've got my eyes on 8 different courts at the moment. It's a little bit of a slow start to the day, but let's go to Judge Shackelford. Let's see what's going on there.
Use of private property to avoid a traffic control device has a fine of $135. You understand that?
Yes, ma'am.
Okay. One second, I'm trying to find the number of points you get for that. Mr. Gazicki, do you know
What's that, Your Honor?
the points for that, using private property to?
I believe it's a 2-point violation.
$500. Two points. You understand that?
Yes, Your Honor.
All right, to the allegation on 10/24 of 24, you violated the laws of the state of Michigan by using private property to avoid a traffic control device, and that you were operating a vehicle with no proof of insurance. How do you plead?
Guilty.
Responsible or not responsible? They're just civil infractions.
Responsible.
All right, I'll accept those two, please. And you can have a payment plan in the amount of $50 a month. Make sure you make those payments. Mr. Fenton, if you don't make those payments, make sure that you contact the court if you're going to be late or don't have the full amount, so you don't end up in warrant status or have additional fines and fees being assessed. Do you understand me?
Yes, Your Honor.
All right, and the misdemeanor is dismissed per the plea agreement.
I just have one question. I don't know if you would know this. Does the 2 points, would that, like, I don't know how many points I have. Does that take away my license? Or
Mr. Fenton, that is something that Secretary of State handles administratively. It depends on how many points you have, what the status of your license is. So you'd have to contact Secretary of State. I can't answer that.
okay. All right.
Okay.
All right. Thank
All
you.
right,
Have a good
we're
day.
all set.
All right.
Thank you.
Yeah.
Okay, well, Judge Shackelford's in between things. Let's head over to Judge Sheila Johnson in Southfield, Michigan, and pay her a visit this morning.
11 fine.
Okay.
If you got that one, do you know if you had, you think you got one right now? You're not sure? Okay.
Will you see?
I was talking to the prosecutor, asking him if he was sure he had a witness. He said he wasn't sure yet.
Okay, all right. Well, that's nice.
Okay,
All right,
so
thank
one witness, and we'll see you then at 11 instead of 10.
you. Just to show something.
Okay, and the bond will be continued.
All right, okay, thank you.
Awesome.
All right, thank you. This is case number 18S00804 FY, People State of Michigan versus Kiana Matthews.
Bert Shacklin, on behalf of the people. Ma'am, please state your name for the record.
Yeah, Matthews. Okay, Miss Matthews, looks like we're here for a sentencing. Okay, and we had adjourned this. Actually, it says sentencing, but that's not what I show here. We ordered disorderly person. This was last year. So what are we here for today? Because it looks like we sentenced you on 4/10. So unless it was a delayed sentence, and it wasn't. Oh, it was a first offender program. Okay. So we don't have an updated report from the probation department on this. So, did you take her down to probation? This is a first offender program and we need an update as to whether she's completed everything. Okay. And then, where's your lawyer?
Yeah.
Yeah, well, I don't have a report for that.
What she's saying is you have to go down to probation, so it's possibly probation officer.
Right, and where's your lawyer? And the lawyer's missing on that. This is a sentence date. So we need to call whoever that is and tell them. She's not been sentenced. Man, what's your problem?
No, I'm saying mine says discharge.
I don't know why they called it that, but it's really a sentencing date to determine if, you know, you've completed everything. It's kind of sort of the same thing, but we're determining whether you've completed everything pursuant to the program. And if so, then you wouldn't be, quote, you wouldn't have this on your record. No, quote, the sentencing would not occur. This would just get discharged, as they said, off your record. Part of the program that you're in, the first offenders program. So we just need to get some information from probation as to what's been going on for the last few months since you've been on this status. So, but your lawyer's supposed to, I think, be here. It's really, it's FOP. It's not a delay. That was last year. Oh. All right. Okay. So we'll pass it and send her downstairs and. Okay. You don't have for that. Okay. They're gonna talk. He'll take you.
You're gonna fall on downstairs.
This is case number 23S00940 ST, State of Michigan versus Demetrius Green.
Robert Shockley on behalf of the people.
All right, Mr. Green, tell us your name.
I think his call is great.
All right, and so, Mr. Green, you're back for a show cause hearing for failure to pay fines and costs. We were here back in February and we adjourned it for you to pay $100 on the fines and costs. You had missed $50 the time before because something about your girlfriend didn't get the bond money back. You said you were going to have a job at Meyer. That's what you said.
Yeah, it's a different job. But they did, they sent the payment plan to the wrong address. I moved. That's why.
Okay. Well, let's do this. You did pay 100 as I asked. I'm going to refer you back to probation, to the collections clerk today so she can get your correct address and work on a payment plan now that you're reemployed and you've paid the 100.
She's starting, I need to see that today. Will that take long?
No.
I could just make the payment alone.
Yeah, with a collection person. We're going to send you down there as soon as the court officer gets back from down there.
So $500, right?
Looks like $520 now. It wouldn't be probation, it's the collections person. So she can work something out with you. You can tell her how much you think you can pay. She can assess your ability to pay with your new job, how much you're making. Last time you were on a, let's see, $50, I think, a month. No, $40. And you're supposed to be done by March 31st of this year. And that was from last year. So now you've caught up a little bit. So maybe you'll pay 50. I don't know. It's up to you and she, how much you determine you can afford per month. Or you might say, I just want to knock it all out and pay the $520 and be done with this. And what
Judge Fleischer has got his court up and running now. Let's check in with him this morning.
9 and .175.
Where was he? Was he in the middle of the road?
It sounds like,
He,
yeah, I don't. So it says that he was sitting inside his vehicle on the 400 block of West Gray Street, which is accessible to the public. On a public road.
don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street is a public street.
I mean, I need more information. I mean, does it say he's on the street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on
Yeah,
that.
I'm sorry, I'm gonna find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. We have every single day. Look, this weekend, how many people died on the road here in Harris County? Really, be smart.
Thank you.
You have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm gonna find no probable cause.
All right, Judge, next is case 4, Door, Adam.
Yes, sir.
Mr. Dory, you're charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Officer was dispatched to a disturbance. The complainant and the defendant are in a dating relationship. The complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain. The officer observed the complainant to have a scratch on her chin, scratches on her arm, and a large purple bruise on her right arm.
We know that he hit her. Do we know?
So the complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
All right, Mr. Doran, we're going to find that there's sufficient probable cause to go forward with your case. This case is 1,139 days old. If you take off again, I'm going to make the bond so high, you'll have hair falling out. Do you understand?
Yes, sir.
As it stands now, I'm going to put an ankle monitor on you so I know where you are at all times. You will have a GPS monitor. I am now also issuing a protective order that you're not to have any contact with this person whatsoever. Miss Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person. Commit and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, be in possession of a weapon, or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this protective order, the state can and will file a violation protective order. It's one of the worst cases you can pick up. Do you have a lawyer today?
No, sir.
What are you doing about that?
Need to find one.
Okay, we will give you time. I'm telling you now, I'm fast tracking this to trial. In 30 days, is discovery complete?
Discovery It looks like we are missing some photos potentially, but besides that, discovery is.
If you can try to get on it, I'm 30 days, I'm putting this case to trial. Do you understand? It would behoove you to immediately go out there and start trying to find a lawyer. I'm gonna have you go to Victoria, sign a reset. After that, you'll get with Fleischer for your bond conditions. So I'm gonna have you take a seat while we create all the documents, we'll have you sign it, and then you'll be free to go, sir.
Yes, sir.
Yeah, I want one now.
And no changes, correct?
Right. Do you have one?
1,000+ days is a long time. I didn't completely catch how that one fell through the cracks, but I don't blame him for wanting to get that resolved quickly.
I just need them to file it, because I don't know if the address is.
Blaze, do you mind filing a new MOA, please?
Sorry, Your Honor?
I'm filing a MOA in this case.
Yes, absolutely, Your Honor. In here as well. But I think go for a second. So. The first. Yeah, that's fine. That's fine. Because I've been in court with this already.
Right, I understand, but it's not. I was in the. Mr. Dixon.
Yes, ma'am.
You have on docket today Macintosh.
Yes, ma'am.
Set for ratings today. You want to go ahead and look for it?
Yes, ma'am.
Page 17, Macintosh.
Macintosh. That's the only reason why. Yeah, it's. Is it a shame you just don't need it? I just want to see if I'm ready. Yeah.
Council, you're.
Yes, sir.
I'm going to say yes.
Yeah, it's fine.
Mr. McIntosh, you're charged, you're on bond for a theft. You've now picked up a new theft. On the new case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, an officer was dispatched to a shoplifting call at Walmart in Harris County, Texas. The officer made contact with the asset protection staff. The complainant stated that he recognized the defendant from a previous encounter. The complainant observed the defendant grab multiple items and attempted to leave the store, passing all points of sale without attempting to pay. Defendant stated he owned a Purple Heart Veterans discount and therefore the amount
That
stolen.
was the first theft, right? I remember that from the first one. That's 254, right?
Right, so, no, this is 255. So maybe similar facts.
And that's the exact, then that must be the exact same as the first one.
Let me check.
It's.
Right. Yeah, that's my thought. So the older theft is from December 16th, 2024.
Right.
And that was from Melrose, and this is from a Walmart, and this is on March 6, 2025. I'm not seeing anything on the previous theft regarding the Purple Heart discount.
Okay.
Would you like me to start over?
Just so, to Walmart and how much?
$283.62.
Judge, if you can recall, this is the young man that you had granted a pretrial, you had given a bond for him. You had me to talk to his mother to see if his mother would have a place for him to stay. And she said yes, providing that he puts up an effort to try to get a job and et cetera.
Oh, I remember that.
Yes, sir.
Okay. But he now picked up a new case.
Now, he had.
Have we addressed that since the new?
Yeah, we addressed it. We knew that he had picked up another case. That's why you were upset that he had picked up another case while he was on bond for the previous theft. But the court was kind enough to still give him a bond, because I had spoken with the mother, and the mother informed me that, he could stay there and, where, until such time that he.
Are we doing another arraignment then
Right.
today?
Yeah, bond conditions have already been set for this.
Vic, why are we doing a arraignment? And is today just a regular setting then? I'm showing them both set for,
They were signed.
Door?
Okay, yes, Judge, I guess it was just a regular setting. He
Don't-
had a PR bond, and on the
Right.
bond, it had today's date of billing.
if you pick up a third case, I'm going to absolutely lose it. Do you understand?
Yes, Your Honor.
You must get a job or be in school full-time.
Yes, Your Honor.
Do not use any illegal drugs. If I find that you're using, I will lock you up. Do
Yes,
you
Your Honor.
understand? We've given you now 2 PR bonds on the first one, 1 PR bond on the second case. That's 3 PR bonds. You will not get another one. Do you understand?
Yes, Your Honor.
In the next couple weeks, I'm going to send you for a drug test. If I find that you're using, it's not going to go well for you. Okay, so I guess let's set this case out for a couple weeks because I want to know what he's done to get a job. I'm setting your case out for 1 to 2 weeks. I want to see what you have done to get a job. If you have done nothing, if you come here and show me that you have not filled out at least 10 to 15 applications for a job somewhere, it's not going to go well for you. Do you understand?
Yes, Your Honor.
All right, so 1 to 2 weeks, you're going to get tested when you come back.
Yes, Your Honor.
Understand?
Yes, sir.
Okay. All right, Mr. Lee, thank you.
Thank you, Your Honor.
Thank you.
Have a seat.
Thank you, sir.
Marcus, ready?
Judge, yes, approach on Mr. Perez, it's an arraignment.
Page 20.
May I call him up?
Yeah, please.
Ricardo Perez.
So real quick, that last one was uncharacteristically messy for a Judge Fleischer court that nobody really knew what was going on. That was weird. I've got my eyes on 8 different courtrooms at the moment, but we'll continue with Judge Fleischer.
Perez, you were charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay. Hi, good morning.
On March 16th, 2025, officers were dispatched to an assault with injuries located at 4,000 Hollister in Harris County, Texas. The officers were unable to speak with the complainant because his injuries caused him to be unconscious. Officers reviewed surveillance, which showed that the defendant pushed down the complainant with both of his hands, causing the complainant to hit his head first on the concrete. It also showed the complainant to be unconscious. The defendant was identified through a witness who called him out on the scene and identified him. And the defendant matched the person in the surveillance footage.
Where was this? Is it at a bar? You're drinking? What?
It doesn't state, it just gives an address.
I believe it was at an apartment complex where he resides, my understanding. I guess we'll see what the surveillance shows.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I want you to understand that I'm going to do everything in my power to protect my city at all costs. This is now your second assault within the last 1.5 to 2 years. If I find that you so much as put hands on any single person, I'm going to lock you up. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you. Do you understand?
Usted lo entiende.
Yes.
Yes.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to random you. If I find that you're using likewise, I will put you in jail. You're ordered not to have any contact with the complaining witness in this case, not to be in possession of any weapons, or not to go within 200 feet of where he lives or where he works. For now, I will have you go to Ramona, to Victoria to sign a reset. After that, I'll get you with Fleischer for your bond conditions. Be careful. You are skirting extremely thin ice. Do you understand? If that ice cracks, your butt's gonna freeze. Come on.
This way.
You want me to adjust my other,
Come on.
I have three others. Cruz, Jose Cruz.
Okay.
We submitted the PT application mitigation and the TRAS. We're just waiting on, it was approved. We're waiting on the contract.
Okay, so let's set it 2 weeks for you to get everything done.
Okay. Can I waive my client's appearance?
Yeah, if he doesn't have everything done though, then he's gotta be here because it's an old case.
Okay, he's here today.
Okay.
Okay.
I'll waive it as long as he's, got everything done. They're ready to file the supervision order and,
Okay.
okay,
Next one is Guevara, Guevara, Jose.
okay.
We're waiting on approval. We submitted the PT application and mitigation on Friday. This is the one that we had talked like a week ago, that we just found out he needed it, so we submitted everything. We're waiting on approval.
Okay, I guess let's do it again. We'll give it another week.
2 weeks?
No, 1 week.
1 week.
It's 250 days.
Okay, and then, the last
Same
one,
thing, it'll be waived if it's not approved or denied by the next one, then I'll send an email myself because it's, yeah. Okay.
my last one is Diego Gonzalez. Again, same situation. Last time we were here, Judge, I was emailing back and forth with Ashley. Initially, she had said he's denied because he
no
didn't have
insurance yet,
insurance, and I said,
correct.
no, he does have insurance. And Geico's been trying to get a hold of the CW, and even the DAs are having a hard time getting a hold of the CW. So I'm waiting to hear from her.
I did give her, and you gave it in.
I emailed her both. Yes, I emailed her the letter from Geico and insurance.
Let's give it a week also to see if she approves or denies. Same
Great,
thing.
that's all I got. Thank you, Judge. Maybe excused? Thanks.
This is an off-docket matter. It's just really quick that I want to bring to your attention. Jonathan Lopez, you scheduled him for a TRAS. He refused to do the TRAS. We're due back in court on Monday. I'm not sure if you wanted to put him on docket sooner to address it. Cause number is, second, 255-5478.
This is the one you're on the BPO with funds affairs to right. Address.
Okay, no, just.
We're okay for Monday? Sure. Okay, I just wanted to bring to your attention.
Thank you.
All right, thank you, Judge.
I'll talk to you.
Okay, thank you. May I be excused?
See, I knew it. I'm clairvoyant. I said Ramona. I'm kidding. Ramona, was that it for arraignments, or do we have more? Do you know?
Judge, I'm not sure. The last.
Last one was Perez.
That was good. Yeah, she-
Adrian Hernandez? Oh. Okay. Judge, have you talked to Perez, Ricardo Perez?
We just did that one.
Yeah, we just did.
Yes.
Okay, I think that's all they were.
Well, they figure out what's going on in Judge Fleischer's court. Let's pay a visit back to 14B and Judge Washington.
Approved.
Without, what is the downside on that?
If you come back to the system and they look up your, I can't give you legal advice. So, but I will tell you what happens if you come back to the systems and they look up whether or not you are a good candidate for probation. It will show that you were discharged without improvement, which means
Okay.
that you look like a good candidate for probation.
Okay. Let's go with without so I can start knocking down some more payments on this ticket.
Defendant is discharged from probation. Without improvement. And I'll do a review for you in 90 days on June 23rd, 2025 at 10
Okay.
o'clock p.m. Right now, you're only set up for $25 per month, so it should allow you to, well, no, this says 100. I'm gonna reduce it to $25 per month. So that should allow you to try to get back on your feet.
Okay, thank you.
And we'll consider raising it again once you've gotten your apartment and things are looking better for you and your family.
Okay, thank you.
Your Honor, I apologize. I should have brought this up earlier, but is he on 4A status? So would that include revocation of that?
Second. I don't see that it was put in as that. Johnson, this is not a 4A, is it? No, it's not even.
I don't believe so, Your Honor.
Well, it has non-public all over the front of it.
Oh. Let me double check.
But I don't see.
He was granted a deferred for this, Your Honor.
So, well, Mr. George, what that means if you want to do it this way is that if I do without improvement.
Let's shift gears and go over to Judge Boyd's court. We haven't seen her yet this morning, so let's see what's going on.
Today is your plea deadline date, is that correct?
That's correct.
So, Mr. Pena, are you requesting a jury trial? You need to speak up.
Yes, ma'am.
All right. How long do y'all expect this trial to last?
I was gonna say more four, just because of the amount of witnesses.
All right.
And we would be going to, if anything, jury for punishment.
All right. Ms. Ferguson.
Yes.
I need a jury trial date, 3 days, not including jury selection for this case, please. It's criminal trial division. All right, July 8th. Is everyone agreeable to July 8th?
So just to understand how that works, we picked July 8th?
Yes.
Okay, then yes, that would work.
Okay.
Yes.
All right, what will happen is you'll be brought back July 8th for jury trial. You'll be brought over dressed in whatever attire you have at the jail, whatever civilian clothing you have. If you wish to be attired in something different, you'll have to sign a clothing exchange. And
got it.
counsel, if there's an issue with the clothing exchange, just let the court know and we'll see if we can expedite that.
I gotta decide this. I'll take care of it.
All right, thank you. And before you all leave, if the court can get an acknowledgement of discovery.
Yes, Judge.
All right, thank you. Oh, I'm sorry, sir, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
Thank you, Judge.
Okay, again, I've got my eyes on 9 different courtrooms at the moment. A lot of them are silent. Judges Simpson and Fleischer are not even in the courtroom. A couple others are in recess. Well, Judge Boyd's between things. Let's go over to Southfield. Judge Sheila Johnson. Let's go there.
This bond says 3-3, and he wasn't even arraigned until thought it said 3-10. So it doesn't even, if I'm looking at this, it doesn't look like he was even in jail. This one, let's see. What did he say?
I wasn't. I was pulled over on the traffic. And South issue.
Right. Right.
Yeah.
And that would have maybe been on March 8th. Says March 10th here. Did you come to court the same day you got pulled over?
Yeah, when they pulled me over, I was at work. I was pulled over, I was driving my daughter's car. And I was set to go back to work. And then warrant.
Okay, but my question is, did you go to court the same day you got arrested?
No, I did not.
Do you remember when it was, the next day?
Paid a bond.
You paid the bond. Okay, so he paid the interim bond. So that was on February 6th on the city case. February 28th on the state case. So you couldn't have gotten arrested for them both at the same time. Yeah, so do you remember on February 28th? How did you get stopped then? Okay, well, what about the February 6th one? When you posted bond then?
February 6th, I was arrested myself.
And each time did you spend a day in the jail before you got arraigned? I'm just trying to figure out how much credit to give you.
I spent time that they held me until I posted.
And how much time was that? 1 night, 2 nights? Yeah, well, I'm just gonna, you know what? I'm just gonna give him 1 day because I'm not sure, but we'll give him credit for 1 day. And so it's gonna be a $350 fine, 6 months of probation, 3 days of community service, and that will be on the city case too, as well as the state case. 1 day credit on the state case. You'll pay the $75 crime victims' rights fund, restitution, $230. no alcohol or unprescribed drugs. There's testing. Do not go back to Target, Southfield. Maintain your employment. You're going to do mental health treatment. That can be with Wendell Harris and Jamal Addison. Theft awareness class. All right, and I think that's pretty much concurrent terms on both of these things that you have to do for both cases. So one is a sentence, the other is a delayed sentence. So on the city case, we're going to see you back here on September 24th at 9:30. And you're under sentence now, same terms on the state case. Okay. Well, good luck. He has some bonds we're going to apply. Well, he has Anita Ingram posted. So is it her name?
Okay.
So she has to apply it. Will she apply it? Okay, well, we'll refund it. You'll have to pay that one and the bond on this other case. You posted it. It's $250. I'm going to change that. To $250 personal, and we will apply the $250 cash to the fines and costs. Okay.
We have to.
That'll conclude it. And he's go down to probation once the order is done. Okay, this is case number 250-00031 FY, people of the state of Michigan versus Kennedy Trammell.
Robert Sharp, you have some people.
Morning, Your Honor. Larry Smith, Mr. Trammell.
All right, Smith, good morning. And Mr. Trammell, what's your name? Okay, and you're here for, looks like a probable cause conference. And this is on receiving and concealing stolen property charge. And we were here back in January and we adjourned it over to today because we needed some video discovery. We had print discovery. Okay, so did you get that?
We've had some discussion with the prosecutor as well as counsel.
Yeah, who's the co-defendant? Let's see. Okay. So what do you want to do?
At this time, based on review, we'd like to submit a deviation to the prosecutor. So we're asking for an.
Okay. All right, we have an adjournment for deviation. Yep.
April 7th at 9:30.
Jessica, we need a sucker. Do we have one? We're out.
Actually, circuit in the morning.
Oh, okay. Well, we'll give you a new date.
Court's available April 11th at 9:30.
That should work.
Okay, that's another probable cause conference, April 11th at 9:30 a.m. Okay. So, there's a $1,500 cash for surety bond with some conditions. And he has warrants, they said, out of Third Circuit Court and an extensive criminal history. That's what they wrote at the arraignment.
I've been under the documents. Mr. President, this matter, $1,500.
But that's not the standard, whether you can pay it. The standard is whether or not he's gonna appear and what kind of threat he is to the community. And this is a felony, carries 10 years. So how many days has he been?
70.
70. Okay.
He does have 2 children. He has a 4-month-old and a 3-year-old. His fiance, currently with his fiance, tends to back and support his family. At this point, that's where the or perhaps personal or the amount of cash bond requires.
Okay. Pretrial services report says he was interviewed prior to arraignment. They couldn't catch his fiance to verify anything. He's 33, 3 children, lives in Detroit with his fiance and kids, was employed on a construction site, home improvement and roofing for 6 years. Just hadn't worked since October of last year, laid off, completed a GED. He has multiple outstanding warrants. You can't ask me for a bond and you got multiple outstanding warrants. Let's see what they are. It says here, Mr. Trammell does have an extensive criminal history with a significant pattern of failing to appear. Additionally, this matter does not meet the eligibility criteria of Michigan Statute 765.6A due to the defendant being convicted of at least 2 felonies within the past 5 years. Therefore, he is ineligible for release on personal recognizance, and the court must set a financial bail. You want me to raise it? Because at this point, $1,500 is reasonable. He's not holding for anything else. Let me show you what he's got. He's got like a lot of cases, but the warrants. He's got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 warrants, and a civil warrant on a speeding violation. He just doesn't go back to court on anything. And these are from improper plates to drove while license suspended, to offers to engage in prostitution, to failing to display operator's license, receiving a motor vehicle, false identity statement. I'm not changing this. I can't. Fine is continued.
You consider to consent for living here all. At this point, man, got a form. Then it's starting.
Okay, 4 months.
It's changed.
Your Honor, the defendant was on bond as a 36th District Court for 1 count of deceiving and concealing a stolen motor vehicle that was bound over him, meaning he was on conditions when this crime was probably committed.
And that's likely true. And the date of this offense is January 10th. And he had a 4-month-old when he allegedly did it. So no, I'm not going to change. probably a 1-month-old at that point. All right. Mr. Lowry's gonna be next. Two 50032 FY, State of Michigan versus Troy Lowry.
Shock on behalf. Joshua Cap on behalf of Mr. Lowry, Your Honor.
Okay, Mr. Kaplan, good morning. And Mr. Lowry, your name. Okay, so we're here also on a receiving and concealing stolen property. And I didn't even look to see if it was a motor vehicle. And let's take a quick peek. No, it's just 20,000 or more. So this is the 10-year felony. And I think we had also adjourned this for some hand injury. Yeah.
He had surgery and he's been in treatment.
Yeah, okay.
We are also going to be submitting a deviation letter, so we're requesting an adjournment of the CC.
What did we just give them? April 11th, is that a good day for you?
Jury selection. Sorry.
What's available April 7th at 9:30?
But choose, yeah, I can do 9:30 all.
Okay, April 7th at 9:30. That's a determined probable cause. He's already out, so we'll continue his bond unless you have an issue.
Nope, Your Honor.
Okay, so that bond is continued. New date, April 7th, 9:30 for the results of a deviation request.
Thank you, Your Honor.
Okay, he just needs to wait for his notice. In terms, so Mr. Lowry needs a notice. Okay. Mr. You is
Yes.
his client back up from downstairs? Okay. So that's Kiana McMahon. Yes. I have a report in here. Okay. Recalling case number 18S00804 FY, People State of Michigan versus Kiana Matthews.
Good morning, Your Honor. Carl Euler on behalf of Kiana Matthews.
All right. Good morning. That's your lawyer there. Okay, good. Tell us your name again for the record. Ma'am.
Oh, I thought you were something.
No, well, he just said his name. Okay. And so, sorry. Okay, I can really see. So I want to bring this view up. Okay. I'll do it in a second. All right, so Ms. Matthews, you're here for this was a first offender program sentence. And so this is the review date to see if you've complied with what that sentence was going to be. Mr. Euler, I don't know if you had a chance to review this because I just got it myself. She just went down to probation for compliance purposes. And the report does say the defendant complied with the conditions of the first offender program and that this probation should be terminated, which would mean basically case would be dismissed. Do we have to have the any dismissal form for the first offender program?
I don't believe so, but either way, I can provide one to the court. I just did this morning with a different kid through probation, so I'm sure everyone will be in contact if needs that.
Well, I don't know. So what I'm going to do is note as of today's date. Is there anything you wish to say on behalf of your client, Mr. Euler?
No, Your Honor. I'm glad she completed the program and we'll be able to keep this off her record. I apologize, Your Honor. I didn't have this in my calendar, so I'm not in my suit. Sorry.
That's okay. Yeah, it was over a year ago, and she pled to a disorderly conduct here on April 10th of last year under the first offender program. So I'm willing to go ahead and dismiss the case.
Thank you, Your Honor.
Okay, so that's gonna be a dismissal. As of today, March the 24th of 2025. I don't know if I need an order. I used to have some forms for the first offender program, but they could be old now. And then, see what I got. Well, I got a plea form. Notice of acceptance into the program. Release approval motion and order for dismissal of charges. I don't know if this one is still good, but can you copy that? And I'll sign this document. Mr. Shockley can sign it too, and that'll be a dismissal. Okay? All right. All right, Mr. Euler, you're all set. Thank you so much. We're just gonna give your client a copy of the order, and we can send one to you if you would like it.
Great. Thank you, Your Honor.
Okay, all right.
Have a good
Thank
day.
you. Ma'am, if you just have a seat for a moment, we'll come back with that form.
So real quick, while Judge Johnson is between things, again, I've got my eyes on multiple courtrooms this morning. They're all a little spotty as to what's going on. Judge Fleischer won't have any nails left by the time the morning's over because he keeps chewing on his fingers. For some reason, he's that bored. They really need to get him an Xbox on the bench so he can play Fortnite. He'd be happier. Over in Judge Simpson's court, it's labeled as a DV trial docket this morning, but for some reason they were just discussing matters of sewage. Not sure what that's all about. Several other judges in recess. Honestly, the busiest court at the moment is Judge Johnson, so we're just going to continue with that for a while until I spot something more pertinent. So let's continue with her. Let's do this while Judge Johnson is between things. Let's head over to Clayton County where they're doing first appearances and checking on that.
Let's say.
I would say about at least about maybe from 1,000 to 1,000, but I haven't been working for the last week. I was supposed to start a new job yesterday.
Yeah.
So.
Okay. All right.
I
am going to appoint somebody to represent you. And that'll take care of everything this morning. Thank you, sir. Thank you, sir.
Yes, sir. Thank you, sir.
All right. Thanks. All right. Thanks.
This person, slide down. No empty seats. No empty seats.
All right. Good morning, sir.
All right. Good morning, sir. You state your name.
Good morning. Carlos Abraham.
Let's not do that. They've got an echo going on in their feed that I don't want to listen to, and I'm sure you don't either. Let's head back to Judge Johnson.
Inspector Matthews, could you tell me what your probation officer's name was? Do you know? Caskin, could you take this to, actually, never mind, Mr. Shockley.
Let's go over to Judge Middleton. He's doing a misdemeanor arraignment, it looks like.
The defendant was charged with operating while intoxicated with a third offense, although it wasn't completely clear. He pled to operating while intoxicated second offense, I think, is what the plea was to. I'll have to look. But Autumn has prepared a screening report. And we had talked about this case, our probation department and me, weeks ago. And then again, we did vet this through the sobriety court staffing. And certainly Mr. Craze would be a fit for our sobriety court protocol, but he lives in Indiana. And we had tried to finagle it more than once, but we absolutely cannot, under state guidelines, take someone from out of state into our program. So Autumn looked for alternatives, as in a traditional probation, to deal with this. Yeah, please. I thought I turned it on, but apparently I didn't. The Kramer was out. All right, so that's all on the live stream, but not on the record. So this is People versus Daniel James Craze, 25335 FT. Mr. Craze is his lawyer, here with his lawyer, Mr. Ross Truckee. Good morning, Mr. Truckee.
Good morning.
What would you like me to know?
Well, I think Ms. Kiefer's report really does capture Mr. Craze's status quite well. Upon first meeting him and facing a felony charge where he has no other felony charges, this was something he wanted to take seriously, and it wasn't, how do I stay out of jail? How do I beat this? How do I do any of that? Is, what do you want out of this case? I want to get sober and be done with this life. Mr. Craze has had some professional success. And really, this is the millstone around his neck, is this alcohol problem. You see that he's been drinking heavily for quite a long time. He's taking it seriously as far as I can tell, Judge. I think that he's one of the few people that kind of wants the probation to assist him to get through this mess. I do think he would have been a great candidate for sobriety court. Unfortunately, the state lines being what they are, that's not available, but it appears Ms. Kiefer's structuring the probation to, as closely as possible, track that strategy. So we'd ask that the recommendation be incorporated into the judgment of sentence. The only argument I would have is for the court to reconsider the amount of deferred jail time in the recommendation, based on his conduct that day, the lack of an accident, the lack of extreme driving, things of that nature. Thank you.
The law requires at least 5 days on a drinking driving second offense. Judges weren't imposing it, and the state federal highway funding agency said, if you don't do this, we're not going to fund your roads and highways. So we got a memorandum from the Supreme Court saying, bear in mind, the federal law requires a 5-day minimum sentence for a drinking driving second offense. So I think Autumn has incorporated that into her recommendation. Autumn, anything else you wish to add?
Just that Mr. Craze was very eager to be in our program, hence the recommendation as it is. He did ask during our screening interview if by chance he was to move back to this area within the end of the 2 years, if he would be reconsidered for sobriety court. And I told him it was up to the court at that time and it's a possibility, but we just can't go over that 2-year mark. So at this point, I had advised Mr. Craze to contact for a substance abuse assessment. I believe he was supposed to contact Bowen Center. And I haven't heard from him as of yet, but we discussed everything that would be required of him. He believes he can complete it successfully. The recommendation for the jail is because of that 5-day mandatory, but also because if he wants to be in a sobriety court type program, this is a third technically within a short period of time. And I believe the jail time is warranted in this case.
Yes.
I would update, Mr. Craze has provided that February or April 14th at 10:45 is his assessment at the Bowen Center.
I don't have any objection to that. Your status is weird. You have a Michigan driver's license with a Bronson address. You don't live there. Michigan is gonna revoke your driving privileges. I don't know what Indiana's gonna do. If you were to become a St. Joseph County resident, we could always amend the probation to do sobriety card, in which case I could actually get you a driver's license with an interlock device if you're otherwise eligible for it, and we could do all the treatment involved. You're the kind of person I'd like to get in here. You've got some resources, you're motivated, you're not a kid. We have sometimes difficulty with people in their 20s that aren't ready to get sober. But as people get older, they get sick and tired of being sick and tired. And we have had a lot of success with people like you that want to make changes. So you'd be ideal, but you don't live here. If you do live here, we could perhaps amend it otherwise if it fit. But you talk about, there is a genetic component to alcoholism, and you certainly have it in spades. You got dealt a crappy hand. And not everybody that has the gene becomes an alcoholic, and not everybody that has substance abuse disorder has the gene. But there's a high correlation between the gene and your behavior was just dangerous and far down the path of substance abuse disorder. Sometimes ends with death in a crash or otherwise. As Ross says, you've had some success in your career. You've had some good jobs, management jobs. You apparently have a good job now. It's going to allow you to work remotely. So obviously you've got something on the ball, but this has been disruptive to your life. Ms. Davis, anything you want to tell us?
Your Honor, I'm looking at his case and the charging of it. He did this third OWI in the last couple of years, and he probably deserved to have a felony. But the way that the system is, we wanted to give him the opportunity to have a probation instead of just simply sending him upstairs and potentially getting some jail time, maybe the 30 days, and then, you know, probation, fines and costs go on your way. We felt like it was a better option to keep it downstairs here and have him do an intensive probation so that he doesn't have an issue like this again. If he is able to get into sobriety court, we're certainly not objecting to that. I think it's a great program, but again, there are requirements, and you know, our hope is that he does not go back to drinking whatsoever. The fact that, you know, Mr. Attorney Truckee pointed out, well, there wasn't any dangerous driving, that sort of thing. Yeah, we don't know what his driving looked like from Three Rivers to White Pigeon, and then he was passed out. His behavior was not great to the officers. But, you know, being here today, seeing what Ms. Kiefer has written about him, I think this is a good move, and hopefully this is a probation that is successful. Otherwise, I think the amount of jail that is hanging over his head is
180
appropriate.
days. Now, you look better today than when I first saw you. I think what you told Ms. Kiefer is you had had a drink since this night.
That's correct, sir.
Have you done any support group or anything, or just holding your breath?
No, I've attended AA. I've been reading the Blue Book, Big Book, and I have a support system around me that's.
Where are you doing your AA?
I go to the LaGrange at the Mason Lodge on Sunday mornings, and then I've been doing a couple a week online.
All right, well, that's a good start. And you've got an assessment set for April 11th with the Bowen Center.
April 14th at 10:45.
We've worked with them in the past, a lot, actually. They're a legit operation. And so that's encouraging. Anything else you'd like me to know?
I would like to apologize for what's happened. I realize that it's a disease and I need to do all of this stuff to better my life. And I'm willing to do that.
Well, for one thing, it's expensive.
It is.
The drinking is expensive. Getting arrested and paying fines and costs is expensive. In 2020, they gave you 58 days of jail. In 2023, they gave you 365 days in jail and suspended 360. And so I don't know any of the facts of those. But everybody has a day that they had their last drink in the sobriety community. They'll ask you, what day did you have your last drink? When you go to get your driver's license, they'll ask, what day did you get your last drink? Did you ever have an Indiana driver's license?
I did when I grew up in Shipshewana. About 24, 25 was when I moved to Michigan, at 24, 25 years of age. So I have had an Indiana driver's license.
But you're 44 now and your license has been in Michigan.
Yes.
Now, a couple issues. The Secretary of State thinks you live in Bronson. So they're gonna mail any notices from the Secretary of State to the address on your driver's license. So I would tell you to change your address, but they won't give you a Michigan driver's license or ID because you live in Indiana. Who is in Indiana? Your parents?
Yes. I also have a PO box in Bronson that is set up as like my mailing address.
All right, so will it go to that address?
Yes, sir.
Okay. All right. Before we had sobriety court, we had probation. Judge McManus put thousands of people on probation. There's this picture over there. So did Judge Welty. We started sobriety court about 12 years ago or more. But we had our successes then, maybe not as well. We did. Frankly, some people would, if you did nothing except give them a fine, a certain percentage of the people would get sober anyway. They're tired of that lifestyle. What they said is 25% of the people would change anyway. 25% of the people are never going to change at all. So the treatment courts are working on the 50% of people in the middle that we think we can affect a change with. That was some of the statistics I just got at the treatment court conference. All right, we'll start with a 24-month probation, which can be discharged at the end of 12. I'm gonna order 90 days jail, credit 1, leaving 89 days to serve. Of the 89 days, 85 days are deferred. To be served on weekends. It is expensive. There's a $300 fine, $75 crime victims' rights fee, $50 state minimum fee, screening fee of $100, an attorney fee of $150. There's a probation oversight of $960, which could be cut in half. $120 police reimbursement to the White Pigeon PD. One of these gas stations is outside the village of White Pigeon. But the US 131 is the village limit, but they end up getting called there all the time. And I'm going to order that you continue substance abuse counseling and treatment in AA or support group with a sponsor. That's a big sobriety court tenet. You can watch online sobriety court and sit in the back row and not really engage, or you can go to live meetings and get a real live sponsor that will help you. I'm very pleased that you're getting your assessment. Testing and treatment as directed, no drugs and no alcohol. Test as demanded. Also includes marijuana. I don't get the impression you have any other drug of choice other than alcohol. What was your drink of choice? Rum?
Rum and Coke.
And not to mention all that Coke isn't all that good for you either. All that high caffeine and all that sugar is bad for you. In that amount. All right, Autumn, did I miss anything?
I don't believe so, Your Honor.
The probation can be amended if you move to White Pigeon or Centerville or anywhere here. We would consider it. It really is your only avenue to getting a driver's license. Indiana is not going to give you a driver's license. When they see you've got 2 there and 1 here, if you apply for a license, you won't get one. You already got a Michigan license, which they're going to suspend. But through sobriety court, if you complete a certified sobriety court treatment program, you can get your driver's license back with an interlock device. And then eventually, after successful use of the interlock after you graduate, you can get your full license back. It's hard to do, but people do it. So I'm flexible. Like I said, I think you would be a good fit. We have a couple of people that we're ready to bring in. Your attitude is good. All right. Let's see, judgment. Now, if you get another one of these, at least here, they probably will not reduce it to a misdemeanor. They'll keep it as a felony. And you could even still go into sobriety court as a felon. But I hope we don't ever get to that point. I want you to go with Ms. Kiefer. She's going to get you plugged in, and what you need to do as part of this. We'll get a release from Bowen Center so we can see how you're doing there. You're going to get a sponsor. And, oh, I didn't add up all the fines. You probably added that up in your head, but let's see, 300 plus 125 plus 100 plus 150 plus 960 plus 120. I didn't order victim impact panel. I think you may have been through it in Indiana. 1755.
There is no.
The surety bond. And there was $5,000 down the drain. All right. Let's do 1 year. All right, thank you.
Thank you.
All right, that completes our sentencing docket.
Okie dokie. So the biggest thing that caught my attention on this one, you tell me in the chat if you saw something else, but they said that he was 44. And if you looked at him, he looked a lot older than 44. I've got almost a decade on him, and I feel like I look younger, hairline notwithstanding, than he did. And that is definitely proof in my mind that if you live hard, it definitely ages you. I mean, this was, by my count, his third drunk driving. He definitely has a problem, and he's definitely hurting himself, it would seem. Hopefully he gets his stuff sorted out, not only for himself, but for the safety of the community, because that many drunk drivings is not good. Sooner or later, something's going to go really wrong, and he's going to hurt himself or somebody else, and that's definitely not what they need in St. Joseph County. Most courts are quiet. Let's go to Southfield, Judge Johnson again.
Does anybody have a stapler with staples in it? Oh, you did? Okay, because it didn't have any. That was the last time I used it. Thank you. Okay, so ma'am, let's see. How much money can you pay on this?
Monthly between 100 and 200.
Monthly.
Yes.
You're sure?
Yes.
Okay. How much you bring me today?
Nothing.
Oh, okay. Why not?
I usually can bail myself out.
Okay. Well, so we got money here on a bailout. I don't see it. Let's see. Let's see. Let's see. Do we have money?
Well, my uncle.
I don't see any money here. Where's your aunt? She not with you? She was at work. Okay. I'm gonna adjourn this hearing. You owe $14.14 on embezzlement, and there was another count of embezzlement that you owe $300. So I'm gonna adjourn this. You're gonna bring me back as much money as you can bring me back. You claim 200 is the max you could bring at one time. If you bring that, great. If you can bring 300, even better. And if you make a good faith, good amount of payment on this, I will then re-refer you back for a payment plan. Okay?
Yes.
So how much you think you're gonna bring me?
Okay, I ain't gonna give you a amount, but it's gonna be as much as possible.
Is it gonna be at least the 200 you claim?
Might be more.
All righty. All right. Give her a date. How much time you need to come up with that since you just started?
Like 2.
Okay. So give her a date like 3 weeks out.
At 9:30.
How about that? Okay, April the 16th, 2025 at 9:30 a.m. for show cause. And you're gonna bring me as much as possible, but at least 300, 200. Okay, you're all set. We'll see you then. Oh, sure does, doesn't it? All right. So looks like that does complete the docket. Turn this off. Picked up.
Okie dokie, her docket is done. Let's go to 14B again and Judge Washington.
The court will call the Austin Smith matters 22W003619 A and B. and 22W003600.
Paul Barnett on behalf of the township.
The last report I have is March 20th, and it indicates that he had not made any payments. Madam Reporter, can you tell me if any payments were made between March 20th and now? He's here for failure to appear in contempt. Defendant has failed to appear and failed to pay. Which warrants to issue? Can you look at the 22W3600? How much is owed on that? Mhm. 2,500, 10% on 22W3600. And actually 2,500 on all of them, 10%. Are we ready to recall the State of Michigan versus Angel Gray 25S00090?
Assistant Public Defender Daffy lead before Ms. Dre.
Where is Miss Gray? Okay. We're gonna bring her back. Mr. Lebo, have you and Mr. Mansour communicated since Mr. Mansour had the breakout room?
We
Okay.
have, Your Honor. Thank you.
Ms. Gray, we recalled your case. If you could state your name again.
Angel Gray.
Thank you. All right, Mr. Lebo, where are we?
And we're requesting an adjournment. Ms. Dre would like some time to consider her options.
Okay. Right. Are we asking that the no contact still be lifted if that's the case at this point?
Judge, seeing that they're not going into restorative justice at this point, I would ask for the no contact order to be put.
And I'm scratching out the no contact. That's not going to be lifted at this time. Are you still requesting that she move back to North Carolina?
Yes, Your Honor. And she's not rejecting restorative justice this time. She's just like some time to consider.
Well, unless she's in restorative justice, we're not lifting the no contact provision. So I'm not saying she's rejecting it. I'm just not going to lift the no contact. They should continue to have no contact.
Thank you.
She may move back to North Carolina. And then I'll see her back here. Is 2 weeks enough time to think about this, Ms. Gray?
Yes, that's fine.
All right. April 7th, 2025 at 9:00 a.m. Bond is continued.
Thank you.
We'll talk
Thank
about
you. I appreciate it.
at that time. You're welcome, and have a good day.
You too. Thank you.
Bye-bye.
Really quick, while they're between matters, actually, they may not be between matters. It looks like she's done. Okay. It's a lot of weird this morning. Judges Fleischer and Boyd are not in the courtroom at the moment. Judge Johnson is done. Judge Simpson is labeled as a DV docket, but they're discussing some kind of apartment issue, so that's really odd. I'll be honest with you, in the other courts that I'm monitoring, they're in the middle of trials or larger hearings that it doesn't necessarily make sense to go into. I'd really like to take you to, back to Judge Fleischer, but he's been out of the courtroom for about 20 minutes now. So there's not a lot going on. I think I'm going to go ahead and call it a day 10 minutes early. Not that I want to bail, but I'm not going to show you something that doesn't have any context to it, and anything I'd bring you at the moment isn't going to have any context to it. Now, I will say this, in Friday's hearing, or Friday's docket rather, in Judge Fleischer's court, he had talked about how a trial is supposedly being transferred over to him this week. And if that goes through, and if he streams it, they'll do voir dire for the jury tomorrow, and then they'll do the trial on Wednesday. And assuming he streams that, and he will, I think, as long as a lawyer doesn't object to it, I'll bring that to you. So if you're not already subscribed to the channel, consider doing so, and hit that notification bell so you know when we go live. And my intent is to bring you that if it happens. But again, I think for today, we're going to go ahead and be done, because there's nothing I can show you at the moment in the courtrooms that I'm monitoring, which is up to 13 of them now. But there's nothing that has any really good context to it if we cut there, so it just doesn't make sense. So again, I appreciate all of you joining us today. Again, if you haven't subscribed to the channel, please consider doing so. The live stream is in its 3rd or 4th week now, but it's still relatively new. And we're trying to teach the algorithm that we do have a live show now. So on your way out, if you can do me a favor and smash that like button if you haven't already, that helps the algorithm know that we exist and we keep building and building and building. So I'd appreciate that. But I'm going to quit rambling. Go find yourself something to do. Have a good Monday with whatever it is that you've got going on. Take care and God bless.